Greetings, everyone. Welcome to the DC Bar Pro Bono Center's webinar, Commercial Leasing, an update actually, Commercial Leasing during the pandemic, brought to you in partnership with Blank Rome and the DC Small Business Development Center Network. I'm Daryl Maxwell, an Assistant Director at the DC Bar Pro Bono Center. Before we get started, I'd like to thank a few people. First, I'd like to thank Lauren Paley, our program specialist, for helping make all of this happen, and as well as Christine Kulamani, our staff attorney, helping with the webinar's implementation, as well as collating, putting together some of our early questions to make sure that we can get responses for those who posed said questions. Next, a huge thank you to our friends at Blank Rome, Ross Coe, who's coming back for the second time. He's an associate with Blank Rome and a longtime small business clinic volunteer for the Pro Bono Center. Really appreciate him stepping forward and coming back to us with updates to where we stand on commercial leasing. One last note of thanks to our friends from the DC Small Business Development Center Network, in particular, Charles Mott and Felipe Perez for co-sponsoring this program. Before we get started, I'd like to go over some of the logistics for today's webinar. Many of you will likely ask, so I just wanted to let you know now, this webinar will be recorded. It's being recorded as we speak. Additionally, you have access to this webinar. You have access to a PowerPoint presentation regarding this webinar on your control panel. At the end of the webinar, if you'd like to share a copy of this with a friend, you can go to the Pro Bono Center's resource site, www.lawhelp.org/DC/CED. For questions, please use the question box in the dashboard on your GoToWebinar, and then in the GoToWebinar dashboard. During the presentation, I will share questions with our presenter, Ross Coe. As we continue to adjust to virtual school for our kids, virtual meetings for all of us, reduced capacity in workspaces and commercial spaces, businesses of all types are uncertain what course they will take. After our first webinar on this subject in early May, many of you had questions about your rights as tenants, options for your landlords, as well as strategies for renegotiation. Ross and I will lead this discussion to try to help you find some answers. For right now, Ross, I will turn it over to you to get us going.
Thanks, Daryl, for that introduction, and thanks to the DC Bar Pro Bono Center for inviting me back to speak today. The last presentation that we gave together about commercial leasing was back in April, and a lot has changed since that time. At that time, we were still at the stay-at-home order stage and the closure of non-essential businesses, and some of that material is still relevant today, and I'll try to highlight when it still applies throughout this presentation, but there's been many changes since that time, so it's good that we have the opportunity today to talk about some of those updates and some additional strategies for small businesses in the current stage of the pandemic. So first, before we dig into some of the legal material, let's just review some of the background and what's happened between our last presentation and today. On the left side of this slide, you'll see a number of different metrics that the district is tracking to determine how well we are doing at combating the virus. And I won't pretend to understand all of the figures, but I do know that the yellow boxes relate to what's called phase 1 compliance, and the green boxes indicate that we've satisfied thresholds that would allow the district to move into phase 3. We'll talk about what those phases are in a minute. And this data gets updated regularly. This particular set comes from a recent situational update provided by the District of Columbia on October 5th. But these metrics come out actually on an almost daily basis and are published by the District of Columbia. In terms of the timeline, we had our last webinar on April 30th, and during that time frame, as I mentioned, we were in the stay-at-home and closure of non-essential business stage of the pandemic, and not long after that, a group provided a set of recommendations to the mayor about reopening. This is called the Reopen DC Advisory Group. They issued the recommendations on May 21st. And shortly thereafter, phase one began. So phase one reopening. The DC Advisory Group's recommendations included a 4-phase reopening. So the first phase began at the end of May, and near the end of June, phase 2 began. And that's the phase that we currently still find ourselves in. Subsequent to reopening phase 2, the mayor issued a few additional orders, the first of which clarified the requirements to wear masks indoors and outdoors in DC, and the second of which was a 14-day quarantine requirement, a travel restriction for those returning from high-risk areas. And we'll get into those particular orders and how they impact small businesses in DC. In addition, there was a recent order on October 7th that extended the public health emergency through the end of this year. And I think we should have every reason to believe it would be extended again, but that's where it's currently extended through. And this order provided some modifications to the initial phase 2 framework that the district put in place. So a few more words about the Reopen DC Advisory Group. This is a group that was appointed by Mayor Bowser and advised by Dr. Fauci and Johns Hopkins. And as I mentioned, they proposed a 4-stage or phase reopening plan, and I'll use those words stage and phase interchangeably. As Daryl mentioned, you have these slides available to you, so you can look up afterwards any of the links that I've referenced in the slides. For example, the one here regarding the full report, if you're interested. The 4 recommended stages to reopen DC really track the change in the virus and how we can best and most safely reopen given the changing dynamics of the virus transmission. During stage 1, we were to see sort of a declining virus transmission, and in the current stage under the recommendations by Reopen DC, we're in a stage where we see only localized transmission, less community spread. And stage 3 is really reserved for when we only have sporadic transmission. And stage 4 is when we're at an effective vaccine or cure and we can move to the so-called new normal for DC. The recommendations made by the Reopen DC Advisory Group aren't exactly the same as what the mayor has put into her orders. However, this is really the framework that advised the mayor and the council on how to put those regulations into place. The report also includes this helpful depiction of how moving across those stages should look like for businesses. And I think one of the easiest ones to look at as an example are for office work. During stage 1, the advisory group strongly recommended working from home. And then in stage 2, there's a more limited capacity in office space. And we'll get to what the actual recommendations, what the actual requirements are under the order. And then in stage 3, there's additional capacity permitted for office tenants. And you'll have to look at not only these recommendations, but more importantly, the actual regulations that have been put into effect on the basis of your particular business, because we won't be able to cover each of the details that might apply to your business, but we will cover some of the key requirements in broad brush. We've already moved through phase 1, but just as a reminder of what that means, it was when the stay-at-home order was initially lifted, there were continued social distancing requirements, and there was a prohibition on gatherings of 10 or more. It was when non-essential retail could initially open back up for outdoor pickup and delivery. And there were specific businesses like barbershops and hair salons that could open, but under a set of restrictions. But during phase 1, otherwise, what we refer to as non-essential businesses had to remain physically closed to the public. And that distinction between essential and non-essential businesses is covered in the first presentation. So I would just refer you back to that if you need clarification on that point. In phase 1, outdoor dining was initially permitted with restrictions that were intended to space individuals out and slow the transmission of the virus, but to allow outdoor dining at restaurants in DC. So that's phase 1. And now we've moved into phase 2. And the whole idea of moving into phase 2 was a move from a substantial transmission where significant mitigation steps were warranted to more minimal or moderate community transmission where more moderate mitigation steps were warranted. The social distancing requirements continue. And in addition, you can now have large gatherings of up to 50 subject to certain exceptions. And in addition, this is not necessarily relevant to small businesses, but I'll note that there was a preliminary injunction granted to Capitol Hill Baptist by the U.S. District Court for the District of Columbia to permit outdoor worship services in excess of this 50-person limit. And that injunction applies only to Capitol Hill Baptist during their pending litigation. But I only mention that as a reminder that when we talk about the regulations, that some of them could be subject to court challenges. And I don't think I've seen a lot of cases challenging the restrictions in DC, but there are many challenges nationwide to different restrictions. And this is just one of them that's happened in DC. For those who are able to work remotely, telework is still required to the extent consistent with current business operations. And this particular language about current business operations came about in the more recent October 7th modification by the mayor. That modification also encourages office employers to develop plans to safely return to the office following the Department of Health recommendations by, for example, alternating or staggering employees. During phase 2, indoor shopping is generally permitted, provided that the occupancy may not exceed 50% of the occupancy specified on the certificate of occupancy for the premises, subject to of course, the social distancing and other protocols put in place by the Department of Health. During phase 2, our current phase, additional businesses are permitted to reopen. For example, nail salons and certain other similar establishments are allowed to open now under the same conditions as barbershops and hair salons under phase 1. There's a reopening of child care centers subject to social distancing and hygiene practices, and fitness establishments subject to additional requirements such as a occupancy limitation of 5 persons per 1,000 square feet, which is obviously far more restrictive than the occupancy restrictions prior to coronavirus for a fitness establishment. In addition, under phase 2, outdoor dining continues and any associated permitting fees have been waived by the district. Indoor dining is permitted as well, subject to certain minimum safeguards. Again, the same types of safeguards intended to spread patrons out. And there's a limitation of 50% capacity permitted by the certificate of occupancy indoors at restaurants. However, during our current phase, certain businesses must remain closed. For example, nightclubs, except a nightclub can essentially operate more like a restaurant under the order and subject to alcohol regulatory endorsements under the mayor's order. There's also, other than waivers that you could obtain and subject to a pilot for entertainment that was recently announced in the end of September, theaters, cinema, and other entertainment remains closed under phase 2. After this initial framework was put in place, the mayor also issued a couple of additional orders, the first being this mask requirement. So under the mask requirement, there's a distinction between wearing a mask indoors and wearing the mask outside. The indoor requirement, there's a requirement to wear a mask in the common area of your apartment, condominium, or cooperative. And in addition, there's a requirement more specific to businesses that in a business, office building, or other establishment, there's a requirement to wear a mask. And there's also a requirement for a business to post the signage on their exterior stating that persons must wear a mask to enter. And DC has also developed template signage that you can easily find and download at the website that's listed on this slide. Businesses are also, the onus for enforcing the mask requirement is also put on businesses to some extent. There's a requirement for businesses to either exclude or attempt to eject individuals who are not wearing or who remove their masks in businesses. And employers are required to provide masks to their employees under the order. In terms of outdoor mask requirements, there's a requirement to wear a mask outside if you're likely to come into contact with another person, such as being within 6 feet of another person for more than a fleeting time. Now, there are certain exceptions to the mask requirement. For example, if you're a child age 2 or younger, you'll see on the right side of this slide, there's common exceptions, including if you're a child age 2 or younger, if you're vigorously exercising outdoors, not close to anyone, if you're actively eating or drinking, or you're alone inside of your enclosed office, you're not required to wear a mask. But otherwise, the mask requirements are pretty clear. In addition, if you're a passenger or you're an operator of a public transit, taxi, Uber, Lyft, or anything of that nature, you're required to wear a mask under the order. In addition to the mask requirement, the mayor also put into place a requirement to self-quarantine. And the self-quarantine requirements are divided into two separate sections under the mayor's order. One is for what's called non-essential travel, and the other is for essential travel. So essential travel really goes back to those original definitions that we discussed in a prior presentation of travel related to essential businesses or minimum basic operations. And if you are part of what's deemed an essential business, or you're performing minimum basic operations for your business, then the mayor's order permits you to travel under this essential travel category. And you are not required to quarantine when you return. You're simply required to self-monitor for your symptoms and to quarantine and seek medical attention if you experience symptoms. The order does provide that if you're traveling for essential travel, then to the extent possible, you're required to limit your activities to that exempt purpose for a period of 14 days. So aside from essential travel, if you are traveling to what's referred to as a high-risk area under non-essential travel, and Maryland and Virginia are exempt from those restrictions, then you're required to quarantine for 14 days upon your return to DC. And in addition, as a business, you are allowed to require your employees or customers to affirm compliance with this requirement before allowing entry or providing any services to those customers. This slide shows the most recent map of so-called high-risk states by the District of Columbia, and updates are posted regularly. For example, in this update, New Mexico was added. The next update will be posted on October 19th. So now that we have really some of the background in terms of where we are in the current pandemic, let's talk for a moment about the current business and leasing environment for small businesses. And obviously, this is a challenging time for small businesses, not only because of the having to comply with different regulations, all of which are intended to make reopening safe and to make customers feel more comfortable coming and visiting your business. This virus has resulted in a number of changes nationwide in terms of closures, access to capital, and the like. Based on work from the Wall Street Journal, there's really been we've seen a tightening of lending standards for small businesses, and that loss of access to capital has been particularly difficult for small businesses. It's not something that is shared equally between small and larger businesses. A large corporation can access capital in a very different way than a small business. And if banks tighten their lending standards, then small businesses don't have access to the cash that they need to make it through a challenging time. In addition, the Paycheck Protection Program funds that were intended for small businesses have likely been spent by now. And the Fed created something called the Main Street Lending Program, but it has been unpopular. The program is targeted towards small and medium-sized businesses, but it requires banks to act as an intermediary to lend the funds, and many banks have not taken the Fed up on the program. In addition, while the discussions around additional federal stimulus change almost every day, those additional stimulus funds before the election appear more and more unlikely. The Wall Street Journal also quoted in this recent article about small businesses that their small business transaction data have shown that about 1 in 5 businesses, this is nationwide, that were open in January have stopped transacting entirely. So that's 1 in 5 businesses that most likely have closed for good. And in a more recent survey by a company called Alignable, 42% of small business owners responded that they were at risk of going out of business in the fourth quarter. We've seen not only nationwide, but here in DC, the closure of numerous small businesses in this time. I'm sure that you can think of an example of your own, but the Washington Post recently reported that several long-standing small businesses in DC, such as Wagner Opticians, Bogart Hair Salon, and Twins Jazz Club, have closed. So obviously it's a challenging time in the country and a challenging time in DC for small businesses in particular. There have been changes in terms of when we last spoke about rent collection. Rent was really falling in terms of percentage of rent collection for retail in particular was falling in April when we last spoke. And more recent data show that rent payment has risen over time during the pandemic, so that while less than a third of retail companies paid at least 75% of June rent, by July, the percentage of rent payers had almost doubled. However, the failure to pay rent in full has created tension between tenants and landlords, and we're seeing around the country litigation arise between landlords and tenants where there hasn't been a deal worked out, and there hasn't been, and the tenant has been unable to pay rent. We'll get to some of the protections in DC surrounding that, but I think that's a good background to have in mind. Our last presentation was was much more focused on the specific rent deferral and abatement agreements that we were starting to see negotiated between landlords and tenants in the marketplace. We'll see in a moment that DC put in place its own statutory deferral option for commercial retail tenants and certain other small commercial tenants. But those agreements still apply to some extent. We're not seeing the same level of negotiation around the same volume of negotiation for these amendments, because many tenants have entered into them, but there are some where an agreement has still not been reached and rent still hasn't been paid for a long period of time. And in those cases, we are seeing on a more national basis litigation start to arise. So we'll talk about some of the statutory solution that DC has put in place, but I think it's important to keep in mind that much of what applied in the earlier presentation in terms of negotiating for deferral or abatement with the landlord, or working out a solution with the landlord that results in the landlord not losing a tenant and the space not going dark, but the tenant being able to pay rent to the extent it's able, and working out arrangements that are mutually beneficial to the landlords and the tenants. That still applies, but we'll get to some of the more specific actions now that the DC Council and the Mayor took to alleviate some of the burden that's been placed on tenants under this environment. So in DC, we've had several different iterations now of legislation passed by the DC Council to address the coronavirus. And based on the way the DC Council's ability to legislate under District of Columbia law, under the Home Rule Act, DC cannot pass legislation for other than for this emergency purposes, which lasts only for a period of 90 days without obtaining congressional review. So the current iteration of the Coronavirus Relief Act in DC expires on November 16th based on that 90-day period of time that the council can pass for emergency bills in DC. You can find the full text of the bill at this link. There's also a great resource from the Office of the Tenant Advocate that explains some of the protections that have been put in place in the District of Columbia. But I think it's important to note that this legislation that's been put in place is temporary. It is subject to congressional review, and it requires that we continue to look back and constantly look for updates in terms of new acts that could come out by the DC Council to make sure that we're staying on top of the latest updates and the latest protections for small businesses in DC. If Congress doesn't approve this bill, then of course some of the discussion that we'll have may not apply. The applicability would be called into question, but we'll discuss this legislation because it's the way DC has decided to approach the pandemic and relief during the pandemic. And we're going to focus on Title IV, the housing and tenant protections. So the first section we'll look at is Section 401 of the Act. It provides mortgage relief. It's a requirement for a mortgage lender to develop a deferment program of 90 days of interest and principal, and to waive late fees and other types of fees during the public health emergency. Importantly, the lender may not report this deferral to a credit reporting agency as delinquent, and to qualify, the borrower must simply demonstrate evidence of financial hardship resulting directly or indirectly from the pandemic. In terms of the repayment period, the parties can either reasonably agree upon a time period, or if they cannot reach an agreement, then the repayment period is 3 years from the end of the deferment period or the maturity date of the loan, whichever is sooner. The lender is not allowed to either require or even request a lump sum repayment by the borrower. And this deferment is applicable during the public health emergency and for 60 days thereafter. In addition to addressing mortgages, the council also addressed tenant payment plans under Section 402 of the Act. This section requires all landlords to offer a rent payment plan program for eligible tenants. And landlords are also required to notify all tenants of the availability of this program, the terms of the program, and the application process for it. So small business landlords are required to notify their tenants, and if as a small business tenant you haven't heard and you're an eligible tenant, then the landlord was supposed to notify you of this. Now, an eligible tenant means that as a small business, you will have notified the landlord of your inability to pay all or a portion of the rent due as a result of the pandemic. And in addition, you cannot be a franchisee unless the franchise is owned by a district resident, and you have to be either a residential tenant, a commercial retail tenant, or a commercial tenant of premises comprised of less than 6,500 square feet. So this provision would not apply if your business is not retail, meaning a shop that's open to the public, and your space is larger than 6,500 square feet, 6,500 square feet or larger. This payment plan is applicable during the pandemic and for 1 year thereafter. It covers gross rent and other amounts due under the lease, and with a minimum length of 1 year unless a shorter payment plan term length is requested by the eligible tenant. So gross rent means that it covers not only the base rent due under your lease, but also the pass-throughs or any other amounts that are due under the lease. And it waives any fee, interest, or penalty that arises out of entering into the payment plan. So just thinking back to the prior presentation, we talked about the differences between deferral and abatement. And deferral means that you have to pay the money back to the landlord in the end. And abatement means that you never have to pay it back. So that distinction is still important to keep in mind, but it's important to keep in mind that the district, this particular law, is a deferral plan. It is not an abatement. It means that at the end of the day, you have to pay this back to your landlord. Similar to the mortgage relief, the landlord cannot report to a credit reporting agency as delinquent the amount subject to the payment plan, as long as you're making payments subject to the plan. And there's no loss of rights under the lease as a result of entering into one of these arrangements. The requirement in terms of paying the landlord back is that you're going to pay in equal installments. The landlord cannot require or even request a lump sum repayment. And you have to enter into a written agreement for this plan. The minimum deferral for the plan is 1 year unless you as the tenant request a shorter term. And in order to qualify, a tenant must simply demonstrate evidence of financial hardship resulting directly or indirectly from the public health emergency. If the landlord denies your request for a plan, as a commercial tenant, you can file a written complaint with the Department of Consumer and Regulatory Affairs in DC. And during this program period, if the landlord, unless the landlord offers a payment plan, the landlord is prohibited from filing for a collection lawsuit or eviction for non-payment of rent. And we'll get to the eviction moratorium shortly as well. There's a great resource from DCRA. A link is shown on this slide as well to explain this plan further. So Section 404 of the Act is Prohibition on Eviction, and it applies in DC during the public health emergency and for 60 days thereafter. And this is an interesting provision and unique to DC in some ways, in that the eviction moratorium under the federal relief package expired, and the executive order issued by President Trump regarding evictions has been determined to be ultimately meaningless. But in DC, there is still an eviction moratorium during the pandemic and for 60 days thereafter. And it's phrased in a very broad way. So it would apply for non-payment of rent and for other grounds for eviction as well. And if you go to the DC landlord-tenant website, you can find that over 400 cases are pending that challenge this moratorium. So there is litigation that's arisen because of this moratorium, but it's pretty clear in terms of what it says in the statute, that you cannot be evicted right now. There's also in Section 406 of the Act a prohibition on increases in rent. This applies to the same tenants that can get the payment plan, commercial retail tenants and other commercial tenants if their premises is comprised of less than 6,500 square feet. The rent increase prohibition is applicable during the pandemic and for 30 days thereafter. So if you have rent escalations in your lease, then they would not apply based on this statute during the pandemic if you qualify. So we've really gone through some of the framework that DC has put into place to provide relief to tenants. And we have to keep in mind the earlier presentation that was made in April about abatement and deferment. And those negotiations could continue on with landlords. There's nothing preventing a tenant who otherwise doesn't qualify for the district's relief plan or who wants to negotiate a different arrangement with their landlord that's more specific to them. For example, we discussed in the prior presentation payment of percentage rent or other types of solutions that landlords and tenants are discussing. However, with all of the relief options that DC has provided, we still know that many small businesses continue to struggle. And so I thought it would be useful, and hopefully this material is not something that you need to use, but if you're considering, like so many other small businesses, whether you'll have to close in this fourth quarter or at any time during the pandemic, then I think it's important to think about how to exit most strategically. And so we'll look at some strategies for exiting your commercial lease if you're a tenant and you want to get out of your lease. So the first thing that you really need to think about if you want to walk away from your lease is who signed the lease. And ideally, you would have a limited liability company that owns no other assets that is the signatory under the lease, because that would offer the most protection to you as a tenant. If you individually signed the lease as just under your individual name, then the landlord would have certain rights against you individually. And in addition, there are other options such as a corporation or partnership. And you'd have to consider the extent to which your liability is limited when you walk away from the lease. You also want to consider whether that entity has any other assets. If the entity owns other assets, then the landlord could pursue those assets if you walk away from the lease. In addition, you have to look at whether there was a guarantee signed at any point. The guarantee, if you personally guaranteed a lease, it's almost as if you signed the lease individually. depending on the terms of the guarantee, of course. Most guarantees for small businesses of leases are going to be full payment and performance guarantees. So it's basically as if you had signed the lease yourself. There are some differences in guarantees, so you'll have to look at the specific terms of your guarantee. If it's a corporate guarantee, you're going to need to make the same analysis in terms of what other assets that corporation owns. In addition, you need to think about whether you posted a security deposit or a letter of credit. If you walk away from your lease, then you will not be able to recover your security deposit or letter of credit. So that's another factor to consider. In addition to that consideration, another common exit strategy for a tenant is to either assign or sublet the premises. The assignment and sublet provisions differ from one lease to another, so it's important to look at the exact language in your lease. And the first thing that you want to figure out is whether the landlord's consent is required for you to assign or sublet, and what standard applies if their consent is required. Do they have sole discretion over whether you can assign, or do they need to be reasonable? Some leases provide a lot of detail on this point, and you'll need to become familiar with the standard that applies. In addition to consent required transactions, in some cases, leases contain no consent required assignment and sublet transactions. Most commonly, assignment provisions if you're going to assign to an affiliate. Now, in terms of an exit, that may not be beneficial because you don't want to assign to an affiliate, but there could be other types of no consent transactions depending on how your lease was negotiated. And in those cases, if you find an assignee or a subtenant, then the landlord would not be able to prohibit you from transferring the lease to that transferee. In addition to assigning or subletting directly, some tenants consider whether a sale of the business would be a good exit strategy. If there's a sale of the business, it's often considered a change in control. And under the assignment and sublet provisions in a lease, there's often a language that provides that a change in control is subject to the landlord's consent to the same extent as if you were assigning or subletting the premises. So you need to become familiar with your lease and determine whether there are any restrictions on a change in control and whether you need to obtain the landlord's consent before selling the business if you are a tenant under a lease. Oftentimes, there's advance notice that's required before assigning or subletting, and you have to provide documentation to the landlord. Advance notice could be 30 days, 45 days, or maybe 60 days or even longer. So you need to be aware of the timeline required under your lease. In some cases, as soon as you notify your landlord that you're looking to assign or sublet the lease, the landlord has a recapture option. And to be fair, that could be a perfectly good solution right now if you want to walk away from your lease. But the landlord would be recapturing the space, and if you were to obtain any sort of profit from the assignment or sublet, then you would not be able to keep that. Profit sharing is something that's often discussed. Sometimes it isn't discussed in the assignment provisions, but many times it is. And profit sharing may not apply right now because rents may be lower. You may not be able to get the stated rent under your lease. But profit sharing is when the assignment or sublease rent is higher than the stated rent under the lease. And this provision requires a tenant to either turn over all of those profits after cost to the landlord, or more commonly split those profits 50-50 or some other arrangement that's been negotiated in the original lease. When you're considering whether to assign or sublet, you also, especially as a retail tenant, need to look at some of the other provisions in your lease, such as continuous operation requirements, if there's a required trade name, or the lease specifies a particular use that the tenant must operate for. These types of restrictions could prevent you from assigning or subletting to a tenant that you would prefer if they don't operate, for example, within the same line of business as you, or if they have a different trade name that the landlord doesn't approve of, or simply by closing down, you've breached the continuous operation requirement. During the pandemic, I think there's been a certain level of leniency with respect to continuous operation requirements. But as we've moved on away from the stay-at-home and lockdown orders, those requirements become more top of mind. When you're looking at an assignment or sublease, you also want to determine whether you have continuing liability after the assignment. So in the case of a sublease, you're still going to be on the hook as a tenant. But if you assign a lease to a third party, then oftentimes you continue to have primary liability, unless under the original lease there's a release provision, or you're able to negotiate for a release of liability and or a release of the guarantee as part of your negotiations with the landlord. Let's touch briefly on a few additional points relating to walking away from the lease or inability to pay rent. The first is the duty to mitigate. And a duty to mitigate is a good thing for a tenant to have, because if there's a duty to mitigate under the lease, then that means if you walk away, then the landlord has the obligation to try to lease that space to someone else and to mitigate any damages that you might owe to the landlord. It's been a long-standing rule in DC that if the lease contains a right for the landlord to re-enter and re-let upon the tenant's default while holding the tenant liable for a deficiency, then the landlord is under no obligation to mitigate damages. So if there's no re-entry clause, if there's nothing in the remedies section of your lease that allows the landlord to re-enter and re-let, then there would be a duty to mitigate. It's only if they have the option to, it's only when there's a duty, there's an obligation, there's the option to re-enter and re-let that there is a duty to mitigate. In addition, we talked last time about the Trans-Lux case, which is essentially permits tenants to defer payment of rent and to redeem their lease by payment of that amount after a judgment has been entered, but prior to an eviction. Obviously, you'd have to consider that in light of the eviction moratorium in place in DC right now, but that is the long-standing rule in DC even before the pandemic. The other clause that you should look for if you're considering walking away from your lease is a rent acceleration clause. If the lease contains in the remedies section a clause that provides that the landlord can accelerate all rent due under the lease, then that means that if you walked away, you could owe all of the rent remaining for the rest of the term of the lease. the DC court authority has not actually determined whether rent acceleration is permitted, but they did find in a 2008 case that the landlord may not both terminate a lease and also enforce a rent acceleration clause. So that's a good, this authority helps us see that if you were to walk away from a lease, it would be beneficial to enter into a written termination and surrender agreement, because if there's a written agreement confirming that your lease is terminated and you've surrendered the premises, then the landlord cannot enforce any rent acceleration provision that might be in your lease. So I won't provide a lot of analysis in terms of outlook. I think that there are better sources for that. But I do think it bears mentioning that you should continue to watch for updates that are regularly posted by the mayor and by the District of Columbia at coronavirus.dc.gov. There's constantly updates about different programs and different options that are out there for small businesses. For example, there's a tab for business recovery that describes all of the different grants and assistance that DC has put into place for small businesses, such as a $4 million Streetery Winter Ready grant program and a $3 million small business resiliency fund. So that falls outside the scope of our real estate discussion, but those are things that you should be aware of. I think just before turning to questions, I just wanted to mention that, of course, this is such a challenging time for small businesses, and I hope that today's presentation has been informative for you, and there's been something in here that can help you as you navigate these uncertain times. And thank you again to Daryl and the Pro Bono, DC Pro Bono, for inviting me back to speak with you today.
Ross, thanks so much for agreeing to do this again. I've got a couple of questions. The first is in regards to the eviction prohibition. One of the attendees asks if there are restrictions based on sort of non-retail establishments, much like the payment plans, for folks who is there that same 6,500 square foot non-retail space restriction, or are there no restrictions?
There are not restrictions. It's blanket for both residential and commercial tenants.
Okay, great, good. That's super helpful to know. Let's see. And it's a question we've been getting actually quite a bit over the last couple of months. For business owners whose leases may be expiring at some point, the lease term is ending at some point during these last couple of months. Maybe we're in October, maybe at the end of this month, or that could have happened in are there any issues in the event that maybe the tenant wants to stay and the landlord has chosen to not extend their lease? I'm just trying to figure out. There are lots of clients who've come to us who've said, I want to stay, but my landlord is making it really challenging for me to stay in the space, or there have been also clients who are trying to figure out, well, I think I want to move out of the space, or I want to move out of the space early. I mean, those are two separate issues, but wanted to get sort of an idea of what to do if your lease is about to end and you're thinking about maybe sticking around, or conversely, if maybe you've got a year or two left and you think you need to leave early.
Mm-hmm. Those are good questions. And if you're in a position where your lease is about to expire and you don't have a renewal option, and you're considering whether to stay over, then absent an agreement with the landlord, if you stay in the space, then you would be considered a holdover tenant, and you would have to pay holdover rent. So obviously, if you qualify for the payment plan, the deferral could still apply in that case. But at the end of the day, you still owe the rent under a deferral plan, and so you would still be required to pay rent at that higher amount. Oftentimes, that higher amount could be 150% or 200% of the rent that's otherwise due under your lease. So generally, it would be advisable to work out some sort of arrangement with your landlord, a modification, if you are going to stay in the space. And if you're, sorry, the other question is if you're in a position where you want to leave early.
Right. Yeah. Let's say you've got maybe 2 years left on your lease, and you realize it's probably not. I'm assuming that you start thinking about sort of assignment or negotiating an early exit.
Right. I mean, I think that's the situation we were sort of looking at in terms of analyzing what your exposure is if you were to just hand back the keys, thinking about the option of an assignment or sublet or a sale of your business, or working out a surrender agreement with your landlord where they take back the space. Those are really the options to think through.
Okay, and then for particularly at this time period, let's say, and obviously these can be fairly fact specific, but generally, if you're in a position where you can maintain a space, but you're thinking about renegotiating. Are there any sort of tips or suggestions that you might have for a client who is thinking about maybe working, opting to either stay in a space or move into a new space, and then with that, try to negotiate down the price or not, the rent, or try to renegotiate or try to negotiate sort of not too many sort of increases in the rent. That's I think that's a couple people have asked that.
Right. No, I think that we have to acknowledge that the market has changed because of events, and tenants should look at the most recent available market data to figure out what the best what the market rents are for their space now, or new spaces that they're looking to enter into, and to seek the advice of a broker or other professional who specializes in negotiating rents to make sure that they're negotiating the best agreement for them at this time.
Okay. And then additionally, if you're coming to the end of your lease, but there is some sort of portion, maybe let's say you're coming to the end of your lease, and we're in October, so at the end of the month, but there's some portion of which of that time where you could not you could not pay your lease on a regular basis. I'm guessing that you will, trying to figure out sort of what the financial responsibilities are for the business owner who maybe missed a couple of months worth of rent, maybe let's say April to June. What are the responsibilities for that business owner to the landlord before they turn their keys in?
I think that's a good question. Obviously, if there is no agreement in place, then the tenant would owe that rent. If they qualified under the repayment plan, then I think there could be some question even if they didn't enter into one, but they had been in discussions with their landlord, had notified the landlord of their inability to pay, that there could be some deferral arrangement. But the law, the DC law itself, doesn't provide for abatement. It provides for deferral. So absent some sort of abatement agreement or an agreement when you surrender the space in writing, waiving those amounts, they would still be due by the tenant.
Okay. I think those, I think we got a lot of questions, but I think we touched on a lot of the sort of prep questions that we have that folks who had registered had asked beforehand. So what I want to mention to all of you guys who are on right now is I am putting in the chat a link to our commercial leasing brief advice project, which allows for folks to get assistance reviewing your lease. We just started this during the pandemic, and it has continued to be popular, and we try to make sure that we can take a look at your lease, give you strategies, and great volunteers like Ross, who's been leading us today, have been extremely beneficial and help folks sort of figure out sort of what their next move might be. As we come to the end here, I just wanted to first say thanks to all of you for your interest and your participation and your questions. You can feel free to virtually applaud Ross since we can't all be together. The Pro Bono Center will be sending out a survey to all of you after the fact, and there will be information both about our commercial leasing project, as well as our now weekly small business clinic that you can sign up, register for, and get questions answered related to your leases, your contracts, and intellectual property and things like that. Again, if you'd like to get access to more of our resources, you can visit us at www.lawhelp.org/DC/CED. And again, like I mentioned, you can get information about our commercial leasing project at https probono.center/commercial lease advice. Again, thanks to Ross and our friends at Blank Rome, as well as the DC Small Business Development Center Network for partnering with us. Have a wonderful day.